So you're familiar with the case of United States Trust Company of New York?
Yes.
So that was a case where the United States Supreme Court reversed the New Jersey Supreme Court, correct?
Yes, Your Honor.
Under the Federal Contracts Clause, correct?
Yes, Your Honor.
So some of the facts in that case for us.
Your Honor, I think U.S. Trust is distinguishable in several respects. One, both parties, and that's on page 17 of the opinion, both parties agreed that there was a contract in that case. Here, that's at the essence of the dispute. Second, the money...
Assume there is a contract. I'm sorry. Assume that there is a contract here.
Okay. And then the other way that they are dispositively different is that the monies at issue were Port Authority funds. They were never monies in the general fund. So the appropriations clause was not implicated.
Okay. I'm sorry. I thought you were going to tell us a little bit about the case. Tell me if I'm mistaken. The New Jersey legislature, New York legislature, had provided funding for bondholders. And I'm going to make this very simple. And then in 1974, the legislature happened to repeal, in part, the funding source for those bondholders. And the United States Supreme Court said that that was an impairment of the contract of those earlier bondholders.
And the appropriations clause and the debt limitation clause and the veto clause were not implicated in that case, because in that case the revenues were not general fund revenues. They were Port Authority revenues. So they were not binding.
So let me read. I want to read to you a sentence from the opinion and just comment on it. Whatever the propriety of the state's binding itself to a future course of conduct in other contexts, the power to enter into effective financial contracts cannot be questioned. Any financial obligation could be regarded in theory as a relinquishment of the state's spending power, since money spent to repay debts is not available for other purposes. Similarly, the taxing power may have to be exercised if debts are to be repaid. Notwithstanding these effects, the court has regularly held that the states are bound by their debt contracts.
And
what do you think the U.S. Supreme Court meant by that?
I think the U.S. Supreme Court, as interpreted by the federal courts below, was discussing what it termed a purely financial contract that the state entered into. It was, do we sweep into the general fund revenues from the tolls of the Port Authority that were pledged to the bondholders? And subsequent federal courts have said, when you're dealing, especially the First Circuit in United Auto and the Second and Fourth Circuit in Buffalo Teacher and Baltimore Teachers, has said that when you're dealing with budget matters, you're implicating sovereign concerns as well as just the purely financial concerns.
That was addressed by the Supreme Court in that case. So, and I'm quoting the state in that case. The state promised that revenues and reserves securing the bonds would not be depleted by the Port Authority's operation of deficit-producing passenger railroads beyond the level of permitted deficits. Such a promise is purely financial and thus not necessarily a compromise of the state's reserved powers. It seems to indicate that the state has to make good on its financial obligations. And it also held the state to a higher standard than private contractors, because the opinion says that the state can always act in self-interest to try to wiggle out of its obligations. And the Supreme Court held a very, very high standard before the state would be able to do that. Am I mistaken?
And I think you read the key word, Your Honor. It was a purely financial obligation at issue in United States Trust. The fiscal provisions of the state constitution were not implicated, nor were the rights of the individual citizens to have needs reassessed each year implicated.
There's a difference between an argument that says there is a contract and there's a contract that is unenforceable for any number of reasons. What do we have in the statute in front of us? Because the consequences from that answer may differ.
We have a contract that is subject to appropriation.
even though the language subject to appropriation is nowhere in the statute and it appears regularly elsewhere. You're inserting those words.
Yes, Your Honor, because that's the undeviating principle on which the state has operated. And that's from the appropriations clause. It's from the paramount focus of the 1947 Constitutional Convention, which said that there must be a single Appropriations Act each year under the control of the then current legislature.
So you're making an argument that there can be no contract that the state enters is any good or can be enforced because the next legislature can refuse to fund it. That's at bottom. That's it. Because if this legislation isn't the formation of a contract, then it's impossible for the state to enter into a contract with anyone. And if that's the case, you're also arguing the state can never be held bound to its commitment and promises. Am I mistaken?
Your Honor, the constitutional divide is every non-voter approved contract is subject to appropriation. That's not only the import and purpose of the appropriations clause, it's this court's holding in Camden v. Byrne, and it's the legislature's acknowledgement
but
in
the federal
language
Constitution,
Provision 72.
But we weren't dealing with the federal contract clause in Camden versus Byrne. So I will read to you another line from the U.S. Supreme Court opinion that reverses an earliest New Jersey Supreme Court. Quote, I'm quoting, you're familiar with this language. Thus, a state cannot refuse to meet its legitimate financial obligations simply because it would prefer to spend the money to promote the public good rather than the private welfare of its creditors. And it went on, we can only sustain the repeal of the 1962 covenant if that impairment was both reasonable and necessary to serve the admittedly important purposes claimed by the state.
And again, I would say the two distinguishing features are that case, everyone admitted there was a contract. The question of the fiscal clauses preventing the formation of a valid contract was never at issue. And the fiscal clauses simply were not issued at all because it was revenues from the Port that the Port Authority generated that never made their way into the general fund.
So this is the last quote that I will read to you from this opinion for your comment. A governmental entity can always find a use for extra money, especially when taxes do not have to be raised. If a state could reduce its financial obligations whenever it wanted to spend the money for what it regarded as an important public purpose, the contract clause would provide no protection at all. And isn't that what you're arguing now? Basically a reversal of that very language in that opinion.
No, Your Honor, the federal courts like Baltimore Teachers and Buffalo Teachers, United Auto, that have interpreted that language have said that when you're dealing in a budget context with sovereign interest and responsibilities, that it cannot be the answer that, oh, you can always raise taxes or you can always
Can you totally defund the public defender's office? Can a legislature say, during this fiscal year, no indigent person will have counsel because we just can't afford it? Do you think that would constitutionally fly?
Your Honor, I think that would fall on this side of the constitutional divide.
Because you would have each of those criminal defendants would have a constitutional right to counsel under the Sixth Amendment.
Yes.
So you'd have to
come up. The voters would have approved that constitutional right and the necessary expenditure of monies to vindicate it.
In U.S. Trust, weren't they dealing with toll monies?
Yes, Your Honor.
They weren't dealing with taxpayer-funded general fund, the taxpayer-funded general fund, were they?
Exactly.
Isn't that one of the differences?
Exactly.
That the state could not appropriate that money for some other use, or wasn't that? And did this court deal with that very issue of their obligation to fulfill contractual provisions in Enorado and other cases that have been cited to you, Lonigan? Didn't they deal with that?
Yes, Your Honor.
And how did this court deal with it in the past?
And the dividing line in all of those cases with regard to the debt limitation clause has been whenever it came into apparent conflict with the contract clause, the dividing line was if the statutory requirement to make an appropriation is truly voluntary, then it doesn't violate the debt limitation clause and it's okay. If, however, in those few cases where the court said, well, no, this is a legally binding contract, it found the contract void as violative of the debt limitation clause. And as for the appropriations clause, this court has been consistent in saying that a statutory dedication of funds cannot serve as a self-executing, continuing appropriation, because that would violate the appropriation and debt limitation clause.
If this question had been presented to the voters of New Jersey, the funding, the appropriation to fund the pension, and it had passed, would we be in a different place right now?
Absolutely, Your Honor. We would be on a completely different constitutional footing.
Doesn't the United States Constitution and or the Supreme Court and U.S. Trust say that the first step in this type of analysis is determine whether the state can actually enter into a contract that limits its ability and its power to act in the future? That's the first analysis in the contract clause?
Yes, it does.
Does this statute fail in that initial analysis?
No, it does not, because in that case the court made a distinction between the limited ability of the state to limit its sovereign powers dealing with police power or eminent domain, and it distinguished the ability to enter into financial obligations or financial contracts. As to the former, it did indicate that that type of contract might be void or might not be valid, but that as to contracts which involve financial obligations, the state could do so. And in fact, the dissent raised that
could do so, but it didn't have an untrammeled ability to do so. It was subject to a determination and analysis, was it not?
I'm sorry, I didn't.
It was subject to analysis to whether in certain these type of financial contracts whether it could or could not. They didn't have the absolute right to do it.
No, Your Honor, I would say that what the court made a distinction between contracts which deal with the police power, such as eminent domain, and which they probably do not have the authority to bind themselves, and contracts which involve financial obligations, which they do have the authority to enter into contracts. So I think the Supreme Court answered that question by making that distinction, and I think that they were fairly clear in making that distinction. Mm-hmm. This case would clearly fall under the second provision, which is a financial obligation. Therefore, they have the initial authority to enter into this type of contract.
Mr. Weissman suggested you might be able to help us with the third part of the analysis, whether an impairment is reasonable and necessary to serve the public interest. What standard would courts use in order to make that judgment?
Well, Your Honor, I first of all, on the underlying question of whether this is appropriate for the judiciary, I think that the court in U.S. Trust has already answered that question, and also the court in, I think it was General Motors v. Romaine, answered the question and said it's the court's responsibility to do a reasonable and necessary analysis. The court put it there and put on the judiciary the obligation to do that analysis. It's not an analysis for the state to do in the first place. It's not an analysis for the plaintiffs to do. It's an analysis that the courts are supposed to do, and the U.S. Supreme Court has several times committed the judiciary to making that type of analysis.
So help us understand how we would go about doing so without delving into pure policy and political questions.
Well, the courts around the country have repeatedly done this. I mean, I think that in every case cited by both parties, the courts have engaged in an analysis of not only substantial impairment, and I believe, by the way, in every case they have found substantial impairment, but the courts have engaged in an analysis of reasonable and necessary, and they've come out both ways. The Supreme Court in West Virginia, in the Dadisman v. Moore case dealing with pension contributions, went through an analysis of reasonable and necessary and found that the state did not have a reasonable and necessary basis. The appellate court in California in Corey v. Valdez did an analysis based also on underfunding of the pension system. Then you have, in the Second Circuit, you have the surrogates case, which we cited. You have various cases from the Supreme Courts of Massachusetts, and I believe it was Michigan, which we cited. You also have cases that have made the determination of reasonable and necessary and have determined that the state met its obligation. For example, the Buffalo case, the court went through an analysis of what the city and state had done, and they did the same thing in the Baltimore case. I believe in the Buffalo case, the city had raised...
In this case, as part of the record, are certifications from key state officials saying, we don't have the money. Right?
Yes, but saying you don't have the money is not the answer. First of all, in the U.S. Trust case...
So are there some... is there to be the taking of testimony from these officials?
Well, normally this has been done by certifications and affidavits in most of these cases. But I think you can get a sense of the standard from the Donovan v. Patterson case, which is a federal district court in New York, which states that the state has to do more than offer generalities as to how the public employee expenses were such a large part of the budget and savings could be found there.
But obviously the budgeting process, which is going on as we speak, less than a half a mile from here, is enormously complex. And look at the effort that the legislature puts in every year. I don't think there is any case that you've cited that would require this court or a court, if your analysis were to be accepted, to go through and essentially evaluate the legislative and by extension executive judgments that are entered into in the budget process that would not entail judicial budgeting.
Well, Your Honor, I think in U.S. Trust, the Supreme Court said that the states do not, the argument in U.S. Trust, one of the arguments made by the state was that these types of decisions as to what to do were left up to the legislative discretion. And the U.S. Supreme Court said, no, not really. We're going to look at reasonable and necessary, and we're going to examine what you're doing. Now, if you're asking the more particular questions of what will the judiciary actually look at and what will they do, I think that Justice Lavecchia raised one of the issues that a court can do. And that is, first of all, we think that we have a contractual obligation which is above the binding nature or the lack of a binding nature of an appropriation bond. For 50 years, the state has come before this court and said that an appropriation bond is not really binding on it. It is always subject to appropriation. Here, the treasurer in his certification said, we are paying appropriation bonds.
Let's take that through, and please keep in mind also the Chief's question about standards. Okay, let's say the challenge is that the state is paying its debt, all different kinds of debt. It's paying on contracts that are competing. It's paying for education. It's paying for assistance to people with disabilities. It's paying for medical care. It's paying for all of these things. And your argument would be, and I'm sure ably made, well, this is as important a competing consideration as these other things. In order to evaluate that, wouldn't this court have to get an understanding of all of those competing considerations that can't be simply submitted by paper? They're not done by paper down the street at the State House. They're done by testimony. They're done by an evaluative process that the legislature goes through. They're ultimately done by vote of the representatives of the people. So how could this possibly be accomplished in some summary paper form without essentially the budgeting process being followed by the sort of budget point two in the judiciary?
Well, I think, Your Honor, that the U.S. Supreme Court in U.S. Trust addressed this issue to a certain extent. And they said, and I don't have the quote here, but
I have it for you, and then I'll give it to you and then answer the question. If a state could reduce its financial obligations whenever it wanted to spend the money for what it regarded as an important public purpose, the contract clause would provide no protection at all. Okay, now you have the quote.
That's not actually the sentence.
You want another one? Only so much help I can give.
You got to pay for the next sentence.
Yeah.
That one was free.
And I give you a hint. I think it's further along. The sentence is that the state cannot treat its contractual obligations on a par with other policy alternatives. So you cannot treat the contractual obligation on a par with other policy alternatives.
Well, I'll give you the quote. You wanted it. A state is not completely free to consider impairing the obligation of its own contracts on a par with other policy alternatives.
I was close.
Okay. Yeah, pretty good.
I think that addresses some of the issues that you've raised and that Justice Lavecchia raised before, and that is when you have a contractual obligation to pay into the pension fund, and for the moment I'm going to assume that that's a contractual obligation, that is not on a par, that is above the non-contractual obligation to make the appropriation bond payments. So the Supreme Court has already indicated to us that you cannot look to matters which are below import or below the binding nature of a contract.
Is it above education? Is the contract right you're talking about, does it take priority above education? Because that's not a contractual right. You're not even arguing that.
Your Honor, I think one of the problems here is that we always look at these cases after the fact.
I know, if you wouldn't mind, if you could answer that question, because I think you're telling us that this would take priority over virtually everything, and the court, in its future role in this process, would make those determinations. So we can take any number of policy priorities: Medicaid, education, public safety, all of those things. Are you saying that this court the standard to be applied would be that this right, this contractual right that you're asserting, would take priority over every other budgeting priority?
The answer is no. And
okay, I'm going to stop you there. Who makes the determination as to which one of those budgeting priorities this right would have preference over?
Your Honor, I think the approach taken by the courts that have grappled with the reasonable and necessary is not so much which policy has priority over another policy. It's what efforts did the state make to find this money? What did they do? In the Buffalo case, they raised taxes twice. They had layoffs. They had reductions in salary. They went through a series of other options and alternatives before this.
I'll stop you there, and I apologize for the interruptions, but I want to understand your position. Would it be an appropriate judicial function for a court to say, you know what, you have to lay off people? Sorry to say it, but that's just the way it is.
No, I don't foresee the court coming in and saying what you should do. I think that the court's role would be to say, what you did was not really enough.
Is there a distinction? Because if the state comes in and says, we would have to lay people off, let's just use layoffs, we would have to lay people off in order to do this, and the court then says, well, then that's not satisfaction of reasonable and necessary under the contract analysis, that's in essence saying you have to lay people off.
No,
right?
It's not. And I think Judge Jacobson dealt with this in her opinion. She basically said to go back and have the legislature and the governor try this again.
I take it that's your position is, at least at this particular point, is that Judge Jacobson decided not to meddle into the relationship between the governor and the legislature, made a pronouncement, and said there was an impairment, now figure it out.
Exactly. And in answer to the question, and I am trying to answer your question fully and directly, as to issues such as Medicare, Medicaid, education, although there is some amount of education which is constitutionally required, but even dealing with some of the aid to the municipalities and counties, etc. What I think the courts look to in their reasonable and necessary analysis is, what did you do? What did you try to do? And if you try to do everything that was reasonable, then we will accept what you did.
But if you look at the interplay, if this is going on every year, and the state makes a presentation that the particular things we did, Your Honors, or Your Honor, or Your Honors, are reasonable and necessary. We did layoffs, we increased taxes, we did this and all of these other things. And the court then says, well, that's not enough, that's not reasonable and necessary. That's in essence saying to the state, go do the things we say are reasonable and necessary. And at that point, the court is essentially dictating the budget.
No.
It may not happen in the form that is quite as sharp as I'm saying it, but in essence, that would be the process, because people generally litigate in a way and make presentations that they know from past experience are going to be successful.
Well, Your Honor, I disagree with that, because I think what the court would say to the state is go back and try again. You did not make reasonable efforts. You did not look at all your options. You did not, the Second Circuit, and I believe the U.S. Supreme Court in U.S. Trust certainly suggested that raising taxes is an option. The Second Circuit in the surrogates case said that's definitely something you have to consider. In the Buffalo case, the court pointed out that they had raised taxes
Doesn't
twice.
that illustrate my point? I think what you're saying is the court is put in an annual position of saying to the state, and we may all be gone by this time, this may be 10 or 20 years away, you got to raise taxes.
Well,
You
no,
have to raise
see,
taxes. You have to cut spending.
No, we're looking at it from a reverse point of view. What I'm saying is in those cases, the court looked at what the state did and said, you made a reasonable effort. You raised the taxes twice. Or in Baltimore, they didn't raise taxes, but they went through a whole series of cuts.
What happens when, and I say when, not if, we do what, if we should follow the trial courts, agree with the trial court, and send it back to the legislature, what happens when the legislature and the governor do not reach an agreement?
And they come back to the court and say,
Oh, I don't know where they go. I think that's their decision, but
Well, we
I
have
got a
some
hunch
of the
they might come
legislature
back
here
here. I'm
today.
just throwing it out there. What
Well,
happens
They
when
know
that
the
happens?
address, let's put it that
Your
way.
Honor,
And
I
the phone
think
number.
at that point, when they haven't been able to work it out, the court will see what efforts were made. And I think that's the key that's the point I'm trying to make, is the court will not say, do this, do this, do this. The court will look and see, what have you tried to do? I don't think the court would say, do what
They
the
don't
governor
agree.
does, or
They
do
don't
what the
agree.
legislature does.
They can't do anything. They can't raise taxes. They can't labor. They
Right.
don't agree. What happens then when that happens?
Well, Your Honor, if the legislature and the governor have not passed an appropriation bill, I don't know that the court can do anything. I mean, basically you have no legislation, no final action going before the court. What you have is basically the other two branches saying,
Right.
we can't do anything,
Let me ask you the next question.
which means they don't have a budget.
Let me ask you the next question. And we heard the Assistant Attorney General posit this. The governor exercised his right on veto. That veto was not overridden. Do you agree that, therefore, the legislature and the governor have acted with respect to this budget?
No, I would not agree that the legislature acted with the budget. I think that there's no obligation on the legislature to override a veto in order to express its intent. First of all, for political reasons, Your Honor is aware that getting 67% vote is a very difficult thing in the legislature, in any legislature. And I don't think that as a matter of law, the failure to override a veto is an indication of legislative consent.
Anything else you'd like to add to your argument? Have a look.
If the court has no further questions, then
Thank you.
thank you.